Hello, my name is Margaret Wong, and I'm a practicing immigration lawyer. A big part of being an immigration lawyer is working with clients. There are actually two ways to practice immigration law. One way is to represent employers. One way is to represent aliens. Again, the parallel track. Everything in immigration law is parallel track. It's like Gail Sheehy's book when she was young and when I was young, and I love that book called Passages. Passages is at what certain age you do certain things. Am I representing the employer or am I representing the alien? Let's assume I'm representing employer A. He wants to hire this alien who's a foreign student in America. In fact, that's how I came to America. I came as an F1, I was a foreign student. So if the employer wants to hire someone like me, what do I do? Employer's goals are only two. How fast can I get him or her to work for me? And what kind of visa do I need? And how much does it cost me? That's the employer's goal. But the alien's goals are different. Aside from how fast could I work, the more question is, will I get this visa? If I don't get this visa, will I be illegal or undocumented? And if I get undocumented, what happens to me? How could I just stay in America with no visa? So when I started practicing in 1976, we mostly represented an employer because mostly in those days, alien work is not that huge, number one, and most people don't care. So the alien practice really grew after April of '98 because now they're talking about each new entry is a new entry. In the olden days, before then, and I'm glad I started practicing in 1976, those were to us the good old days. Once you get a green card, you leave, you come back, you leave, you come back. Of course, we go home and visit, we go to Europe to visit, we go on a cruise, we come back, it's considered a new entry. After 98, 97, now it's considered another entry. So anytime you have a criminal record, it stops that entry, you see? So that's why in the olden days it's called exclusion and deportation. Now it's all called removal. And that's why the NTA started. Clients are so important. Number one, without clients, you can't be great. Clients give us the job. Clients pay our mortgages. Clients pay our employees to build a team. So we need clients. So who are our clients? You have your employment-based, the H-1B, the O-1, the J-1. Those are all employer-based. You have the alien practice. After about year 2000, more and more immigration lawyers are divided into employer-based or alien-based. So if you read our web and our resumes, they always say, I represent employers. I represent undocumented aliens. We are more civil rights, you see? So after year 2000, I became very much alien practice, even though we have a great employment-based team, because it's a different type of practice. Divided into alien practice, you also have litigation and family law. What's family law? You have Child Protection Act, Child Passport Act, adoption law. Adoption is becoming a problem after 07, 08 because of the Hague Convention. Remember those Russian kids that got sent back because the adopted parents didn't like them? So now the Hague Convention came in, and just like the people need visas, they don't care. I already got them a green card, I got them citizenship, but I don't like my adopted child, I send them back to Russia. There's always immigration fraud, but the sad thing about that is the media play it up. Anytime there's a benefit, that's fraud. Benefit, fraud. Employer-based, alien-based, all right? So clients, you have to know who you represent.